Imagine waking up in 2026 to find your bank accounts completely frozen, your driver's license flagged, and a massive legal lien placed on your home, all because you unknowingly broke a brand new law. You might have seen the terrifying rumors spreading like wildfire online. Is Florida actually planning to criminalize seniors? While you won't be thrown in a jail cell just for turning 65, the real truth is far more dangerous. Right now, Florida lawmakers are quietly rolling out a web of hidden laws and brutal legal traps that will drastically target your money, your privacy, and your property in 2026. These aren't just rumors. They are heavily documented legal shifts that could instantly bankrupt you or criminalize everyday mistakes. Whether you are 25 or 65, if you or your parents live in Florida, you cannot afford to scroll past this. Let's expose the 10 hidden laws that could ruin your future before it's too late. Number 1. The 45-day bank account freeze. Here is where it gets absolutely terrifying. Imagine walking into a dealership to buy that RV you've saved decades for, or trying to wire money to your grandchild for their college tuition. You swipe your debit card, and it's declined. You check your banking app, only to find that your entire life savings is suddenly locked down. This isn't a glitch. It's Florida Senate Bill 556, designed to combat the explosive rise in elder financial abuse. This new law grants financial institutions the ultimate authority to unilaterally freeze your transactions for up to 45 business days if their algorithms detect suspected exploitation. While behavioral finance studies prove that rapid intervention is the single most effective way to stop foreign scammers from draining a senior's account, the collateral damage is massive. An automated security system cannot tell the difference between a malicious fraudster and you simply making an unusual, well-deserved purchase. So, how do you prevent being digitally locked out of your own life? You must take back control today. Call your financial institution immediately and demand to establish a formal, trusted emergency contact. This ensures that if the bank's AI flags an unusual transaction, a human representative will call your designated family member to verify it, rather than instantly freezing your assets and causing a nightmare. Furthermore, always pre-authorize large transfers by calling your local branch ahead of time. Taking 15 minutes today to update your banking profile could save you from 45 days of agonizing financial paralysis. Protect your money now. But while a frozen bank account is a stressful headache, it is absolutely nothing compared to losing the fundamental right to exist in your own city. Wait until you see what happens when the sun goes down. Number 2. The public sleeping ban. We've all seen the alarming headlines about skyrocketing rent, insurance hikes, and inflation completely transforming Florida's housing market. But what happens when an older adult on a fixed income can no longer afford their monthly rent? In the past, they might have temporarily slept in their car or a local park while figuring things out. But moving into 2026, that desperate survival tactic will effectively become a criminal offense. Under the newly passed Florida House Bill 1365, counties and municipalities are strictly prohibited from allowing unauthorized public sleeping or camping on public property, streets, and sidewalks. While this legislation is broadly aimed at managing urban homelessness, demographic experts and sociologists point out a heartbreaking, scientifically backed reality. Older adults are currently the fastest growing segment of the unhoused population. If a senior is priced out of their apartment and forced to sleep in their vehicle, they aren't just down on their luck. They are now breaking state law, risking aggressive citations, fines, or even arrest. You cannot wait until a crisis hits to figure this out. Your action step. If you or an aging parent are living paycheck to paycheck primarily on Social Security, you must proactively research Florida's subsidized elder housing programs and local emergency rental grants right now. You need to get your name on affordable housing waitlists years in advance, because the legal safety net of simply figuring it out later has been entirely dismantled. Protecting your housing is absolutely critical. But what if you already own your home? Don't breathe a sigh of relief just yet. Wait until you see the new brutal mandate that is legally forcing thousands of Florida homeowners into immediate crushing debt. Number 3. The brutal condo reserve mandate. If you thought losing a rental was bad, wait until you hear what is happening to Florida homeowners. For decades, seniors and young professionals alike flocked to Florida's beautiful, affordable condominiums. But in the wake of the tragic Surfside condo collapse, the state government passed some of the strictest structural safety laws in the country. And by the end of 2025, the financial grace period completely runs out. Under these new mandates, condominium homeowners associations, HOAs, are legally prohibited from waiving their reserve funds. This means older buildings must have 100% of the cash on hand to fix roofs, structural integrity, and plumbing. While this law is a necessary, scientifically backed safety measure to prevent another tragic building collapse, the immediate financial reality for residents is absolutely devastating. If your condo building has been underfunding its reserves for the last 20 years, your HOA is legally required to hit you with a special assessment. We are talking about sudden, mandatory bills of $20,000, $50,000, or even $100,000 per unit. If an older adult on a fixed income, or a young family just scraping by, cannot pay this massive bill, the HOA has the absolute legal right to place a lien on the property and foreclose on their home. You could lose everything you've worked for, completely legally. Your action step: do not stick your head in the sand. Email your HOA board today and demand a copy of your building's structural integrity reserve study. If your building is massively underfunded, you need to call a family meeting right now. You either need to aggressively budget for an impending fee hike or seriously consider selling the property before the 2026 legal deadlines hit. Losing your home to an HOA is a nightmare, but what if giving a simple gift to your grandchild legally disqualifies you from receiving life-saving medical care? Wait until you hear this next one. Number 4. The Medicaid 5-year look-back trap. Losing your home is a nightmare, but what if a simple act of generosity legally disqualified you from receiving life-saving medical care? Imagine you are 60 years old, and you decide to give your 25-year-old daughter $20,000 to help her afford the down payment on her first home. Fast forward 4 years, you suffer an unexpected medical emergency and suddenly require long-term nursing home care. You apply for Medicaid, expecting your lifetime of paying taxes to finally protect you. Instead, your application is flat-out denied, and you are hit with a massive financial penalty. This is the brutal, hidden reality of the Medicaid 5-year look-back trap. By 2026, Florida's Medicaid penalty divisor is increasing dramatically. When you apply for long-term medical care, the government will meticulously audit 5 full years of your financial history. If they find that you transferred assets, gifted money to a grandchild, or even sold a car to a relative below market value, they assume you were illegally trying to hide wealth. They will instantly penalize you by legally withholding your care for months, leaving your family scrambling to pay upwards of $10,000 a month out of pocket. Your action step: do not ever try to informally spend down or gift your assets to qualify for future assistance. Whether you are 45 or 65, if you are planning your estate or helping aging parents, you must consult a certified elder law attorney before transferring a single dollar. They can set up legal, state-approved vehicles like personal services contracts to protect your generational wealth without violating state law. Giving a gift shouldn't ruin your life. But while protecting your money from the government is crucial, wait until you hear the shocking new law that forces you to surrender your physical identity just to use the internet. Which of these hidden laws made your jaw hit the floor? Drop your thoughts in the comments below. I want to know if you're staying to navigate these new rules or packing your bags. We pour countless hours of deep research into exposing the truth for you. So please support our hard work by hitting that subscribe button. It's just one click for you, but it keeps this channel alive. And don't leave just yet. Click the video on your screen right now to watch my previous upload where I reveal even more crucial legal traps. And I'll see you over there. Number 5. The ID for speech social media ban. Giving a gift shouldn't ruin your financial future. But what if you had to surrender your physical identity just to watch a video online? Florida recently made global headlines by passing House Bill 3, sweeping legislation designed to restrict minors from accessing addictive social media platforms. The developmental psychology behind protecting young, impressionable brains from digital algorithms is rock solid. But here is the massive, hidden catch that impacts every single adult in the state. To legally prove you aren't a minor, major tech giants are now forced to implement strict, mandatory age verification. Imagine trying to log into your favorite app to read the news or see pictures of your grandchildren, only to be hit with a hard lock screen demanding you upload a high-resolution photograph of your driver's license, passport, or government-issued ID. You are effectively being forced to hand over your most sensitive physical documents to massive tech companies just to participate in modern society. You are trading your absolute digital privacy for legal compliance. If one of these platforms suffers a massive data breach, which happens constantly, your full legal identity is instantly exposed to the dark web. Your action step: you must become fiercely protective of your personal data. Do not blindly upload your ID to every app that asks. Only provide your credentials through third-party, encrypted verification portals that automatically delete your images after scanning. Furthermore, take 10 minutes today to freeze your credit reports with the 3 major bureaus. It is completely free, and it is the single most effective shield against devastating identity theft. Surrendering your digital privacy is a bitter pill to swallow. But wait until you hear how easily a bitter family member can legally weaponize the courts to freeze your entire estate without ever hiring a lawyer. Number 6. The exploitation injunction weaponization. Surrendering your digital privacy is a bitter pill to swallow. But wait until you hear how easily a bitter family member can legally weaponize the courts to freeze your entire estate without even hiring a lawyer. Welcome to the dark side of Florida's injunction for protection against exploitation. On paper, this law is a brilliant, necessary legal mechanism. It allows vulnerable adults to rapidly freeze their assets to stop foreign scammers and fraudsters in their tracks, completely waiving standard court filing fees to ensure swift justice. However, estate attorneys and legal scholars are witnessing a terrifying new trend. This law is being aggressively weaponized in family inheritance disputes. Imagine you are 55 years old, dedicating your life to helping manage your 85-year-old mother's daily finances and medical care. Your estranged sibling, out of jealousy or greed, files a baseless exploitation injunction against you. Because the law prioritizes rapid protection over immediate evidence, a judge can instantly freeze your mother's entire estate and potentially any shared bank accounts before anyone even steps foot in a courtroom to hear the truth. Your mother's life savings are locked in a bureaucratic nightmare, and you are suddenly treated like a financial criminal. Your action step: do not leave your family's future open to interpretation or sibling rivalry. Whether you are planning your own future or protecting your parents, you must draft an airtight, heavily detailed, durable power of attorney right now. By legally documenting your exact financial wishes and clearly designating who is in charge in writing, you strip away a bitter relative's ability to manipulate the court system against you. Family betrayal is devastating, but what if the state decided to attach your most private medical secrets directly to your car? Wait until you hear this next one. Number 7. The targeted vehicle registration. Family betrayal in the court system is devastating, but what if the state decided to attach your most intensely private medical secrets directly to the registration of your car? This brings us to Florida House Bill 341, a law born out of tragedy but fraught with massive privacy risks. Florida now allows drivers to attach a formal medical diagnosis of a cognitive disability or disorder, like Alzheimer's or dementia, directly to their official motor vehicle registration. The neurological and behavioral science behind this initiative is entirely noble. Studies show that when law enforcement officers pull over an erratic driver, immediately knowing the driver suffers from severe cognitive decline rapidly de-escalates the situation and prevents tragic use of force misunderstandings. It is designed to save the lives of wandering seniors. However, civil rights and digital privacy advocates are sounding a massive alarm. By legally embedding your cognitive decline into a permanent state database tied to your vehicle, you are essentially wearing a bureaucratic target on your back. You are permanently sacrificing your right to medical privacy to the state. Your action step: if you are navigating the heartbreaking reality of caring for a parent with memory loss, you must sit down and make a highly strategic choice this week. You need to weigh the physical safety benefits against the permanent loss of privacy. If you decide that broadcasting a dementia diagnosis to the state is too risky, do not use the DMV registry. Instead, invest in discreet GPS wearables or smart tracking tags placed securely in their wallet, shoes, or vehicle. You can maintain their physical safety without ever surrendering their private medical history to the government. Losing your medical privacy is a heavy burden, But wait until you see how a single, innocent typo on a simple piece of paper could trigger a massive legal investigation and permanently strip away your right to vote. Number 8. Stricter voter registration hurdles. Losing your medical privacy is a heavy burden. But wait until you see how a single, innocent typo on a simple piece of paper could trigger a massive legal investigation and permanently strip away your constitutional right to vote. For decades, updating your voter registration was as easy as checking a single box while renewing your license at the DMV. Not anymore. With the passage of Florida House Bill 135 and a slew of strict new election security measures, the state has completely overhauled the registration and mail-in voting process. The rules are now a massive bureaucratic maze requiring specific printed receipts, exact matching wet signatures, and strict identification numbers. While the stated goal is to ensure absolute election integrity, political science research shows these extreme hurdles disproportionately threaten older adults, individuals with disabilities, and busy working professionals. If a senior with a slight hand tremor signs their mail-in ballot and it doesn't perfectly match the signature on their decades-old driver's license, the ballot is instantly rejected. Worse, if someone accidentally votes in the wrong precinct after moving into an assisted living facility, they aren't just given a polite warning. They can be swept up in a highly publicized voter fraud investigation and face actual felony charges. An innocent mistake can suddenly make you a criminal. Your action step: do not wait until election week to figure this out. Go to Florida's official election portal online today and meticulously verify your exact voter registration status, your active address, and your signature file. If you are helping an aging parent, sit down and walk them through this process immediately. Being stripped of your right to vote over a technicality is tragic. But wait until you see how using a simple iPad to plan your future could accidentally destroy your family's entire inheritance. Number 9. The digital estate planning trap. Being stripped of your right to vote over a technicality is tragic. But wait until you see how using a simple iPad to plan your future could accidentally destroy your family's entire inheritance. Welcome to the double-edged sword of the digital estate planning revolution. Florida has aggressively embraced the modern age, legally allowing for electronic wills and remote video notarization. On the surface, this sounds like an incredible time-saving convenience. Why sit in a stuffy law office when you can just download a cheap app and draft your final wishes from the comfort of your living room couch? Here is the horrifying reality that probate judges are currently warning against. Recent legal case studies show a massive, terrifying spike in invalidated estates directly caused by DIY digital wills. Florida's statutory requirements for electronic signatures and remote video witnessing are incredibly strict and highly technical. If your video witness loses their internet connection for just 5 seconds, or if you use a non-certified digital signature platform, the court can legally declare your entire life's wishes completely null and void. Your family will instantly be thrown into a vicious, deeply expensive probate battle over a simple technological glitch. Your action step: you must stop treating your legacy like a casual online purchase. You can absolutely embrace the convenience of digital planning, but you must never finalize an electronic will without a licensed estate attorney reviewing the final document and officially conducting the remote notarization. Paying for a professional legal review today is the ultimate insurance policy for your family's financial survival tomorrow. Losing an inheritance to a computer glitch is heartbreaking. But wait until you see the new, highly publicized law that was designed to save you taxes, but could accidentally trigger a massive retroactive property tax bill that legally bankrupts your estate. Number 10. The community property trust trap. Losing an inheritance to a computer glitch is heartbreaking. But wait until you see the new, highly publicized law that was designed to save you taxes, but could accidentally trigger a massive retroactive property tax bill that legally bankrupts your estate. Welcome to the hidden danger of Florida House Bill 1093. Recently, Florida modernized its financial laws to allow married couples to create community property trusts. From an economic standpoint, this is a massive win. It allows families to take advantage of incredible federal tax loopholes to avoid paying capital gains taxes when a spouse passes away. Financial advisors are aggressively pushing these new trusts as the ultimate wealth-building tool for 2026. But here is the devastating trap nobody is talking about. If you hastily transfer your Florida primary residence into one of these new trusts without using highly specific, state-mandated legal language, you instantly forfeit your homestead exemption. The moment that exemption drops, Florida's Save Our Homes tax cap vanishes. Your property taxes could legally double or triple overnight, and the county property appraiser can hit you with a massive, retroactive tax bill for thousands of dollars. If an older couple on a fixed income cannot suddenly afford an explosive property tax hike, the county will place a tax lien on the house and sell it right out from under them. Your action step: do not fall for generic financial advice you see online. Never transfer your primary residence into any new trust structure without explicit, written clearance from both a certified CPA and a specialized estate attorney who understand the exact nuances of Florida's homestead laws. These aren't just obscure legal codes. They are the absolute new rules of the game. Navigating aging, housing, and finances in Florida requires you to be fiercely proactive, not reactive. You have the power to protect yourself and your family, but only if you take action today. If this video opened your eyes and gave you the tools to protect your future, smash that like button and subscribe to the channel for more life-changing, research-backed content. I want to hear from you right now. Drop a comment below. What age group are you in, and which of these 10 laws shocked you the most? And your education doesn't stop here. If this blew your mind, wait until you see what I reveal in the next video about the hidden tax loopholes middle-class families are using to build massive wealth in 2026. Click the video on your screen to watch it right now.